Our paper is about Section 1 of the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Today, and over the course of the 20th century, this section has been read in perhaps an unusual way. Equal protection is very important. It provides all of the rights of equality that the court enforces. Due process of law is very important. It provides all of the fundamental rights, both incorporation of the Bill of Rights and unenumerated rights. And the privileges and immunities of citizens in the United States is maybe about seaports or something. This is not the standard reading among modern scholars, though. The standard reading among modern scholars is that the Supreme Court has gotten this very wrong. That instead, what matters about equal protection is in particular the protection of the laws, the sort of access to the remedial rights of government, that the Due Process Clause is really about a very limited set of rights of life, liberty, and property, and that the bulk of the rights protected under Section 1 are in the Privileges and Immunities Clause, rights of citizenship, and that is where the action is. Unfortunately, though, the original history of the Privileges and Immunities Clause is highly contested, to say the least. We have Senator Howard introducing it, saying, it would be a curious question to solve. What are the privileges and immunities of citizens? It's certain the clause was inserted in the Constitution for some good purpose, but we're not entirely sure. So how can this be? How can this core of the amendment, which Howard said was the core of the Section 1 protected great fundamental guarantees, how can that be the case when the language of the Privileges and Immunities Clause is just so obscure? We try to answer this by looking at rights of citizenship building on Judd's prior work. And the framework that we're dealing with is one involving both civil and natural rights. In the views of many of those who adopted the 14th Amendment, there were retained natural rights, rights like life and liberty and so on. And then there were civil rights, rights like contract law, that came in as ways of regulating and implementing the various natural rights. There were also political rights, such as voting. We're not going to say as much about those for the moment. These rights included many rights that were designated as rights of citizenship. They could be natural or conventional. In Corfield versus Coriell, Justice Washington described them as those rights which were in their nature fundamental, which, as the PowerPoint chooses to advance, which belong as a right to all free government, citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which compose this union from the time of their becoming free, independent, and sovereign. Now, to understand what's going on here, we have to look at Article 4 on privileges and immunities, which Justice Washington was there construing. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. There are various ways of reading this. We can read it in a non-discrimination way. So you're entitled to some privileges and immunities, which? Well, the ones that you would get in the several states, that citizens of that state enjoy. You are treated the same way as they are. Or you could read it as a fundamental rights way. So you could say that the citizens of each state are entitled to the privileges and immunities of citizens as a package. And where are they entitled to them? In the several states. So on this reading, there's a package of rights which you get. And those are the rights that citizens of any state get, and they get them in all of the several states. So we can illustrate this with a diagram. There might be federal citizenship rights. There might be state citizenship rights from each state. And then in between, there are general citizenship rights that you are guaranteed under Article 4. And these would be defined by general law, by the unwritten law that was shared as the sort of shared substratum of the laws of the different states. Justice Washington talked about them in Corfield, things like property and contract. And many people attributed rights such as the First through Eighth Amendments also to these general citizenship rights. Not because they were in the Constitution, but the existence of the First through Eighth Amendments was good evidence that they were in fact general rights of citizenship. Whereas state rights would cover local rights such as harvesting oysters as in Corfield or voting, and federal rights would cover, seaports and so on. So in this world, a right of citizenship was not completely immune from state regulation. a state might very well regulate your rights to contract by saying that certain kinds of contracts had to be in writing. That's what the police power is for, to be able to regulate rights for public purposes. But sometimes a state could not carry out that kind of regulation. For instance, if it wanted to say that political opponents of the governor can't make contracts, that would either exceed the police power as not being the sort of impartial, public-minded law that the police power authorizes, or that it might violate various express constitutional limits or implied constitutional limits, the sorts of things that a general delegation of legislative power would not have conferred. In those situations, you were abridging the right rather than regulating it, and it was viewed as legally improper. Now, what does being legally improper get you? It would mean that no state could rightfully abridge these rules, and often state courts would say as much. So they would often enforce unenumerated rights that were not specifically mentioned in the state constitution as part of implied limits on state legislative power. But if they went ahead and enforced the state law anyway, often there was no remedy. There was nothing the federal courts could do about this because these questions of general law were not questions of federal law. There was no federal question review. Instead, what the 14th Amendment did is it secured those rights without conferring them. It assumes that various rights of citizenship were there already, and it shifts them to a federal forum. It doesn't nationalize the rights. It doesn't say that now Congress can pass contract law and to protect all of your interests, it doesn't say Congress can pass tort law. It just guarantees that the state will protect these rights in various ways and provides a way of preventing the state from abridging those rights. We think that, as in the example in the book of the blind men looking at the elephant, a lot of existing scholarship on the 14th Amendment correctly picks up on things that the 14th Amendment does, but has not yet put it together. So the 14th Amendment does, in many ways, protect Corfield rights. It does, in many ways, protect rights generally enjoyed by U.S. citizens. It does protect the rights of the Civil Rights Act of 1866. It does protect, whatever PowerPoint is willing to advance, the First through Eighth Amendments. It does protect rights enumerated elsewhere in the Constitution, such as right to habeas corpus. It does protect various rights of equality, but the way that it protects all these things, and what we see as the most plausible understanding of how they all come in together through a very short phrase, is through this understanding of general law. That is the elephant in the room, as it were. So, quick thoughts before we leave on how the 14th Amendment does these things, especially vis-a-vis equality. There are three possibilities or more. One is that everyone gets a common basket of rights. So that's one way of ensuring equality. You'll get them together. Another occurs under the framework of regulation versus abridgment. So the Black Codes, which denied contract and property rights, were seen as a paradigm of abridgment, of a regulation that could not be justified under the existing framework. Moreover, the rights of citizenship themselves may have contained certain kinds of equality rights. So there are lots of discussion, for example, of an exemption from special taxes. Well, what made a tax special such that you couldn't impose it on this person, but you could impose it on, let's say, optometrists? That would be the sort of reasoning that one would have to engage in to figure out what kinds of equality the Privileges and Immunities Clause protected. Some of those distinctions existed at common law, and one question we raise in the paper is whether common law distinctions like coverture were in some sense grandfathered in, or were they subject to review? And so we talk about the Bradwell case, and we don't come to particular conclusions, but sort of raise that issue. Further questions. What about state action? Can Congress act to prevent a state from neglecting equal protection of laws? What about the incorporation of the Bill of Rights? Is it going to be selective because not all of the Bill of Rights represent these general law rights of citizenship? And moreover, can those rights change over time? General law is unwritten, so can the fundamental rights at stake evolve? Do we look to rights commonly recognized today? We note two caveats to this potential position, though again, we come to no firm conclusion. One is that the general law was not merely the output of a 50-state survey, as PowerPoint would tell you if it advanced, but rather a question of what law those statutes in the 50 states actually replaced. What is the existing law that sort of stands in the background of the statutes that are present in various states? Another caveat to note is that it's possible, in light of Corfield's at all times language, that the Privileges and Immunities Clause was inherently backward-looking, that it was looking to rights, as Bradley put it in his dissent in Slaughterhouse, the traditionary rights, sort of rights of Englishmen and so on, that we had inherited from our ancestors, in which the government cannot take away or impair. We recognize that these questions that are left open are enormous questions, and that anyone trying to actually apply the Privileges and Immunities Clause would have to answer them. But we think that this seems to be the best framework for understanding how the clause was supposed to work, and at least points out how these questions would be addressed if it does not yet point to their answers. So thank you very much, and we look forward to your questions.